Good morning, everybody. Welcome to Wednesday morning. My name is Sam Saad, and today we are talking about Florida Realtor listing agreements. We're going to take a deep dive into them, go through the various forms, and I'm pretty excited about this. I've got a PDF that I'll be able to email you at the end of the presentation with all my notes. So hopefully that'll be a helpful tool for you in your practice. So, a little bit about me. For those of you that have seen me before, you know I serve on the variety of committees that draft the agreements that you use every day in your business, and I have a full service law firm for all of your real estate needs. I also have a title company, Paradise Coast Title and Escrow, for all your closing service needs. So happy to participate there. Because I am an attorney, we are going to talk, have a disclaimer that I'm giving you advice today, but it is not advice that you can rely on without a independent verification and attorney-client privilege attaching. The other thing, because we're talking about listing agreements today, I've got a little additional disclaimer. You've got to check with your broker on the things that we talk about today. The the broker is going to have some specific policies that you're going to want to follow, and you're going to need to check with them to verify the things that we talk about today. Today, we're going to talk about the Florida Realtor listing contracts. There are a number of them. Fortunately, many of them are identical except for the agency language. So we'll talk about that. And we'll talk about how to use these tools in your practice every day. So what I'm going to do is I'm going to switch to a PDF version here and share that with you all. All righty, can everybody see my screen with the exclusive right of sale listing agreement?
Yes.
Yes.
Perfect. All righty, so this is the, now let me start off by saying Florida Realtors has uh, four listing exclusive right of sale listing agreements that are exactly the same except for the agency provisions. So what you're looking at today is the right now is the, I'll zoom in here so you can see it, the ERS 21TB. That's the exclusive right of sale transaction broker listing agreement. So that'll be the main document that we go through today, the transaction broker agreement. And then when we get to the single agency and no brokerage relationship documents, I'll show you the differences. So we're going to go through this in detail. I'll show you all the points of the contract, and then we'll switch to the other documents and we'll go through all the other ones. So right off the bat, you can see, by the way, what I've highlighted in purple, I've got comments that we're going to talk about. And then the orange is other parts that you need to be aware of that I'll also point out to you. So starting right off the bat, line 2 of this agreement is the seller's name. For those of you that have taken my sales contract classes, you know the seller can be a complicated thing. Is it an LLC? Is it a trust? Is there a successor trustee? Is it an estate? Who signs for the estate? Who's the personal representative? Is someone using a power of attorney? So you really need to ask your seller what their status is, and you need to do upfront research before you even go on your listing appointment to look at the property, look at the property card on the property appraiser's website, figure out who the owner of the property is, so you can properly interact with them. Then on line 3, you put your full brokerage name. What's an example? ABC Realty. Well, if it's the ABC Realty Corporation, put that full name on there. Don't just put ABC or just the abbreviation for your brokerage, because it's a contract between the brokerage and the seller. So you want to have the appropriate and proper party names on it. Up next, this is an exclusive right to sell the real property, which means, and we'll talk about this in greater detail when we get to the duties section, you, the realtor, have the exclusive right to sell this property and get your commission if anybody buys the property during the term. So the term will start on the day that you put in this blank here on line 6 and ends when you put on the 11:59 on the date you put in this blank. And give yourself time to sell the property. I've had realtors ask me, how long should my listing be for? And I typically say 6 months to a year, unless it's a hot market and you're really moving the properties. But I would say generally people are listing for 6 months to a year. Um, so this also contains, the language here. You will not discriminate in your practice, and the seller certifies that they're legally entitled to convey the property and all improvements. So that's important that they provide that representation. And the contract really it's an agreement between the parties. It contains the representations and warranties of the parties. It's important that the seller understand what they're getting themselves into. Up next, pretty simple, put the street address of the property, put your legal description. Now, you'll notice here, this is a very nice feature in this contract. If you've got a long legal description on line 16, you can check the box for the C attachment, and you can attach like the deed, the prior deed to the property that's going to have the complete legal description on it, or if there's an exhibit A to the prior deed that has the complete legal. Think about if you're selling like a piece of vacant land and it's got a long meets and bounds legal description on it, and you want to get the complete legal on there because that's going to flow through to your contract, to the deed, all the way through the process to make sure you transfer the appropriate title. And then if you've got a multiple attachments, you can put the number. You can put the number or the description here. Same thing with the personal property. If you've got a little bit of personal property that's going to transfer, you can put it on these lines here. Otherwise, you're going to want to use C attachment and you're going to want to make an inventory. So inventories are a little tricky for the realtor because they involve a lot of work. You have to count the spoons and things like that if you're going to do a complete full turnkey inventory. And so I recommend a written inventory whenever you're going to do personal property. Don't just say on your sales contract, as seen on the effective date of the contract or something like that. And if you've got a list that you've pre-made, you can give it to the buyer's agent when they bring you an offer. Up next here, we're talking about the occupancy of the property, whether it's currently occupied or not. If the property is occupied, this contract assumes there's a lease, and you put the end date of the lease here, and that's going to be important because that's also going to flow through to your contract. As you know, you have to check the box for occupancy on your sales contract. Let me just mute these real quick. Okay. So up next now, this is the part that you get into for where the heavy negotiation starts, the price and the terms. What are you going to list this property for? Well, this is where you come in as the realtor, as the marketing expert. You need to make sure that you've looked at your comps, perhaps done a broker price opinion or comparative market analysis, and you're going to negotiate with your seller to get the price that you think the property will sell for, and you're going to put it right here on line 22. Up next, you're going to talk to your seller about what kind of terms are they willing to accept for financing. And are they going to take a cash offer only, conventional, VA, FHA, or other? Obviously, you are going to want to check all of these boxes because you don't want to limit yourself in the type of financing that's acceptable to when you're trying to get a deal done. The other thing that they put in here is the seller financing. The seller will hold a purchase money mortgage in the amount of, and you'll want to talk to the seller about getting enough down payment to cover foreclosure costs, but at the same time, you're going to want to make sure that you are, if you're going to offer seller financing, it's going to be terms that a buyer is going to say, okay, I can afford this mortgage. So be flexible, but 25% down on seller financing is pretty safe and pretty typical. I would not go less than that. So make sure that you calculate backwards for how much your seller is willing to accept from seller financing and any additional terms. Like if your seller, and don't be too specific, but if your seller is saying, I don't want to hold a mortgage for more than 3 years. Okay, so 3-year mortgage. That's pretty fair. But if they say they want like 6 months or 1 year, that's probably not enough for a buyer to get refinanced. So think about the terms that the seller is willing to offer for seller financing when at the listing stage. You can also have the buyer assume an existing mortgage, and then you would put the mortgage terms here. Although I'll tell you, the uh, most mortgages are not assumable. So you'll want to talk to the seller's lender about what the assumptionability of their mortgage is. And then you'll check the box whether the lender approval of assumption is required or is not required or is not known. It probably is required. Just be aware of that if you're going to do an assumption of an existing mortgage. And then just be aware that there are a number of regulations that affect seller finance transactions, and that's Dodd-Frank. I have a whole class on that, but just make your seller aware that the seller financing arrangement is going to be not as flexible as they might think. And then if the seller is willing to pay any expenses, this would be like a concession. If the seller is willing to do that, that goes in this blank right here on line 38. Now, I gotta tell you, when you're negotiating at this listing stage with the seller, they're probably not going to want to make any concessions. But you talk to them, you say, listen, if you're willing to accept FHA financing, there may be some closing cost assistance involved. We can ask for a higher purchase price, and we can help the buyer with the down payment. So understanding the flexibility of the financing options will make a big difference in terms of what seller expenses, what seller is willing to pay towards buyer's closing costs, basically. And then what are you agreeing to do? You're agreeing to make a diligent and continuing effort to get the property sold. And that's your duty. Get the property sold on the best terms possible for your seller. And excuse me. Up next, we're talking about the multiple listing service, the MLS. The broker is obligated to put the property in the MLS within 1 day of public marketing. For those of you that have been in my NABOR classes, it's a much more detailed explanation of what public marketing is in the agreement. Essentially, public marketing is any marketing outside of your brokerage. If you send an email or a text or a phone call to somebody outside of your brokerage, you are engaging in public marketing, and the NAR rules require you to put this property in the MLS within 1 business day of doing that. Okay. And then, of course, the MLS wants you to report the sale once you get it sold, and this authorizes your broker to do exactly that, which is to report the sale in the MLS. And they also agree to the seller is also agreeing to adhere to local MLS policies so you can stay in compliance with your license. The last thing you want to do is get in trouble with the board because your seller asks you to do something that you shouldn't do. Okay.
Sam,
Yes.
if you are announcing on the Facebook page of the community that you have a listing or rental coming in 2 weeks, is that considered advertising?
That's definitely advertising, Tina. The question is, if you put the property address in the listing and in the
No
advertisement,
address, no address, no
oh,
address.
you're just teasing that you're going to have a listing coming.
Yeah, like you have a townhome with the pool coming in on the second week of September.
If you advertise the property specifically, that's public marketing. It's got to be in MLS. So if you just say townhome coming next week,
Yeah,
that's one thing. But if you say townhome coming, you put a picture of the property, that's public marketing.
yeah. Okay, no picture, nothing, just one statement. Okay,
Yep,
thank you.
you're okay then.
Thank you.
Um, so here in section 6, we're talking about your authority, what the seller authorizes the broker to do. And then there's a whole bunch of stuff that we're going to go through here, A through G, that you're supposed to do. And public market the property to the public. What is public marketing? Flyers, yard signs, digital marketing, and public facing websites, all those things that we talk about, email blasts, anything outside of the broker's office. So they're agreeing to place the appropriate signs on the property. You agree to use the seller's name in connection. They agree to allow it on the internet except for the street address, which you can opt out of in this box right here. Or they cannot authorize the public marketing, and they check this box, and you're limited to just in-office marketing. And it says it right here, only agents within the broker's office. And notice here on line 69, your seller needs to initial if they're not going to allow public marketing. Obviously, it's very bad for you because now you're limited to how you can market this property and get it sold. So we want the seller to clearly understand that they're limiting the options for getting the property sold. Okay. So the seller also authorizes you to get information related to the present mortgage, to provide comparative market analysis information of potential buyers. And then here in E on line 72, if you're going to use the lockbox, you check the box here to clearly state that you're allowed to put a lockbox on the property. And of course, that comes with its own, that comes with its own set of liabilities for allowing people into the property when maybe the agent, the listing agent is not there. And remember though, you are responsible for this property now once you put that lockbox on. So be careful who you give access to, to tradespeople, other agents. Never let an unaccompanied person go into the property for a showing, because if something gets lost, stolen, or broken, it's your responsibility. Okay. The other thing is, are you allowed to withhold verbal offers or withhold all offers once the seller accepts a contract for the property? So these are choices that you're going to make with the seller. If they don't want to hear about somebody called you up and said, I'll give you so much for the property without a written offer, then you check the box on line 76 to withhold verbal offers. You also can, again, withhold all offers once the property is under contract. So talk to your seller about how they want communication to occur, and then make a decision and check the appropriate box here on line 76. And then you'll see here F, act as a transaction broker. So this is just clearly stating that this is a transaction broker, which means what? You can go in and talk to buyers and bring your own buyer to the transaction. Of course, follow all the buyer broker rules. And you can sell the property yourself and get both sides of the commission. Okay, virtual office websites. Sometimes these VOWs are useful and people use them. Automatic valuators, the Zillows, the Realtor.coms, all the various ones, Redfin, they all have them now. And the seller either can authorize or not authorize those. And then the seller can authorize comments and reviews. I think there used to be like a Truly, some other websites where you can blog about properties. Whether you want to allow those are choices that you need to discuss with your seller and decide if you want to allow that. Obviously, the big websites, the Zillows, the Realtors, the Redfins, that's a tough question to answer because they compete with you. But that's a marketing decision you'll have to make. Okay. Up next are the seller's obligations. In consideration of broker's obligations, the seller agrees to do things too. Number one, they agree to cooperate with you. They agree to work with you and get this property sold so that you're not wasting your time and your marketing dollars, including referring all inquiries to you. So when the neighbor comes over, because you just put your sign in the yard and said, oh, you're selling the house, my mother might be interested. Well, if the seller has an obligation to come to you and tell you that as quickly as possible so that you can follow up on the leads. If they don't do that, or if they try to go behind your back, you have a cause of action against your seller. You never want to be in that position, but it is possible. And they need to understand that you may be subject to additional MLS obligations and penalties that you need to comply with, so they can't force you to do something that you're not supposed to do. They agree to give you the keys. They agree to make the property available for showings. They agree to let you know if they're going to lease or otherwise mortgage the property. And you think about, why would somebody mortgage the property if they're selling? Well, they may be in a desperate situation and they may need some cash and they may go get a HELOC loan that you're going to have to pay off at closing, or that your title companies have to pay off at closing. So finding out about those things up front and understanding the ramifications, especially for the offer, makes a big deal to you in your marketing. And then most importantly here, they agree to indemnify and hold you harmless from losses, damage, costs, and expenses, including attorney's fees. And this survives the closing of the property. So if they come back to you later and there's a problem, maybe they didn't tell you about a mold problem. Maybe they didn't tell you that the air conditioner was being held together by a baling wire and duct tape because they're just trying to get the house sold. And then the buyer comes back and sues you under Johnson v. Davis. You can go to your seller and say, seller, you owe me because you didn't tell me about this. So this is an important clause, this indemnification and hold harmless agreement. And then if the seller is foreign, they agree to comply with FIRPTA. And then this is a big one here. Seller certifies and represents that seller knows of no such material facts other than the following that affect the property. This is Johnson versus Davis. This is important case law for you, the realtor, because a buyer who finds out later that the air conditioner was not working or that there was mold in the property that the seller hid, not only can they sue the seller, but they can sue you, the realtor. And they say, realtor, you knew about this and didn't tell me. And you're going to come back and say, nope, the seller never told me that they had hid the mold. The seller never told me that they put chewing gum in the leak in the roof, or whatever it is that they do to try and get this, make their property better. And this is an important disclosure for you to have in your toolkit. And then this is a follow-up clause. Seller will immediately inform the broker of any material facts arising after the signing of this agreement. Very important that they will keep you informed. Also, the seller agrees to consult the appropriate professionals so they're not relying on you for tax advice, legal advice, things like that. And then we get into the compensation. The most important part, I think, of the agreement for you is how you get paid. So, seller will compensate the broker as specified below if buyer is procured who is ready, willing, and able to purchase the property or any interest in the property on the terms of this agreement or any other acceptable terms to seller. If you bring a buyer who's ready, willing, and able, you get paid your commission. And obviously, the seller may say, no, I brought the buyer, and that doesn't matter. The seller may say, you didn't help me out, you didn't do what I wanted, doesn't matter. You get paid at closing. and they're going to pay you, a percentage of the purchase price plus maybe a transaction fee here on line 112, or maybe you're just going to take a flat fee commission, and that can also go over here on line 112 in this last box that I'm pointing out now. Note here, closing is not a prerequisite for broker's fee to be earned. You don't have to close to get paid in this contract. You have to do your job. If the seller defaults, if the contract falls apart for some other reason, you may still be owed a commission. Okay. Up next in 8B here, if there's an option, that's an option to purchase the property later. You can collect a percentage or a dollar amount for that. If you lease the property for the seller, you collect a dollar amount or a percentage for that. Now, this is an admonishment here on line 119 to 120. If the property is subject to a separate lease listing and you're doing the sale listing, the seller doesn't have to pay twice. That's all this says. Okay. Broker's fee is due in the following circumstances. If any interest in the property is transferred, whether by sale, lease, or exchange, you get paid, regardless of whether the buyer is secured by the seller, broker, or any other person. I've said this a couple of times. Here you see it in writing. If this property transfers, you get paid. It's very important. If the seller refuses on an offer to accept an offer on the terms listed in this agreement, you get paid. And actually, for those of you that follow my classes, you saw I did the Carmona Realty case a couple weeks ago. That was this case. The seller didn't want to sell for the price that was in the listing agreement. They wanted more money, and the court said, no, no, no. We brought you 8 offers. You owe the commission, and the broker won their commission. Took 5 years of litigation, but they did win their commission. Okay, also, this contract contains a protection period. So say this contract terminates and you have not sold the property, but then a buyer you showed the property to or comes back afterwards and says, maybe I am interested in that property. Well, if it's within so many days that you've listed here on line 125, you get paid. The only time you would not get paid is if the seller relisted with somebody else. Then no fee would be due the broker, as it states here. Okay. Retained deposits. Yes, question, go ahead.
What do you recommend as a amount of days for the protection period? I think I usually put in 90.
Yeah, 90 to 180. Buyers might come back around given the seasonal nature of Florida. I would do at least 90 to 180 days of protection period to make sure that you're not getting backdoored. I think that's fair. Obviously the seller wants it as short as possible and you want as long as possible, but you need to protect yourself. James is asking, how do you enforce the protection period? You need to follow up. If the property, if you see a deed filed on that property within the protection period, you need to look and see, was this somebody you showed the property to that bought the property? And if it was, commission is due. Okay, retained deposits. If the seller gets the deposit in a deposit dispute, then here on line 130, you are entitled to a percentage of that deposit. So you want, half, cover your marketing costs, half the deposit, quarter of the deposit, whatever it is, to get your marketing costs covered. I think that's pretty important. And then, of course, our lawsuit admonishment that commissions are not set by law and are fully negotiable. Okay, the notice to the seller regarding the buyer's broker. Basically here what we're talking about is that the seller may choose to enter into a separate agreement to pay the buyer's broker. As you know, we'll talk more about that in my buyer broker class, but you may be the buyer's broker. So you can do both sides of the deal, and this agreement allows that. Basically, you can double side the deals. Also, you can pay compensation if the seller so provides. You pick a percentage of the commission the compensation that you're going to be receiving. You give it, or you do a flat amount. Forgot to highlight that. Do a flat amount paid to the buyer's broker, or this is the seller authorizes broker. This is where the seller pays the buyer's broker directly. So either come out of your commission in A, or you check box B, and the seller will pay directly. Now think about that. You go back up here. Where is it? Right up here in 112. So if this is a certain percentage up here in line 112, you come down here to line 147, this is going to be a portion of line 112. So make sure they match up. You know, if you're giving away half your compensation to the buyer's broker, make sure it's half the amount, so that you are not giving away all of your commission. If you check box B down here on line 152, then make sure that, you know, for example, and I guess if line 112 is X percentage and line 152 is Y, those two numbers together are the total that the seller is going to pay out. So don't make sure it's not like 10, 12% because you doubled it up. Make sure it's a percentage that the seller is comfortable with. Or you could offer no compensation to a buyer's broker, and you check box C here on line 154.
Question about that. Can
Yes.
that be an up to amount, like say for the buyer's broker compensation from seller? If
You
I put
normally, you
in
normally would
X.
not do that, Christy, and that's because of the settlement agreement. The buyer's broker compensation's got to be set and known to the parties in the buyer broker agreement.
Mhm.
So the settlement doesn't really allow for up to anymore. You just say you'll pay a percentage of the purchase price, and that's it. You know, it's a fixed number these days. I've not seen up to since the settlement agreement.
But that would still be agreed upon in the separate agreement then. Let's just say, for instance, that says 3%, and then the buyer broker, is agrees to 2.5%, then that overrides that B, correct?
Right. It kind of is. It kind of is up to, because the it does say that it'll be set forth in a separate agreement right here. You can see I'm highlighting.
Mm-hmm.
But you're right. If the buyer broker was less than this, you wouldn't pay the full amount. And one thing that none of these agreements say, which I wish they did, is who gets the difference, and the difference would go to the seller.
Thank you.
Yep. Okay, so here we have the brokerage relationship. The broker will act as the transaction broker. And then you see here in section 11, and section 11, by the way, this is the one that's different in each one of these agreements we're going to go through. So section 11, we talk about dealing honestly and fairly, accounting for funds, using skill, care, diligence in the transaction, disclosing facts that materially affect the value, which are not readily observable, presenting all offers and counteroffers in a timely manner, and the limited confidentiality. So this is the transaction broker relationship that you're setting out. And that limited confidentiality is going to be a big deal when you go to try and get the buyer. And we'll talk more about that when we get to the other forms. We'll talk about the differences. So then you've got your conditional termination. At seller's request, broker may agree to conditionally terminate this agreement. And you'll see here on line 163 here at the bottom of page 3, you're going to want to have a fee, a cancellation fee that covers your marketing costs. Don't skimp on the cancellation fee. I see a lot of realtors that are afraid to charge their seller a cancellation fee. And what I would say to you is stand strong. If your seller is not willing to sell this property after they've engaged you and you've spent money, you are owed something. And your marketing expenses or your hard earned dollars are precious. And I would not let a seller bully you by not paying you for them. Della, you're asking, can the seller change their mind of what they're willing to pay the buyer's agent, i.e., pay more? Yes, you can change your mind. Yes, you can. Okay. Um, so you can cancel and then sell to someone else. And you can void the termination. You would void that. You would be owed the commission if that happened. Basically, is the shortest way of saying that. In dispute resolution, you're going to initial if they authorize arbitration. I'm going to tell you, I'm not an arbitration fan. I was a trained mediator and arbiter back in law school, and I really think that they don't work as well as the court system. But you can mediate and then arbitrate this dispute if you don't get your commission. I again don't recommend that. Just sue them. Miscellaneous terms are somewhat important here because it talks about what happens when the seller dies. You know, I live in Southwest Florida, a lot of elderly people, and sometimes they pass away. And you want to make sure that, again, you protect your marketing dollars. And so this protects them that you can keep selling the property in the heirs. And this contract inures to the heirs, successors, and assigns. And then anything that you guys talk about in your texting and your listing presentation need to be written into this agreement or they don't count. And then you've got your additional terms here. And normally when you hear me speak, you'll hear me say, don't use the additional terms without a lawyer on sales contracts. Well, on listing contracts, you can use the additional terms because you are contracting for your broker and yourself, not for somebody else. So it's not necessarily the unlicensed practice of law. Okay.
Can I ask
Yep.
a quick question going
Yes,
back up
Christine.
to arbitration? So that
Yep.
is something that is, you can skip that altogether. It's not required to fill that out. If you
Right.
don't check mark anything or have initials there, then it automatically goes to a court settlement or court case.
Correct. You're right.
Okay.
Court case as opposed to arbitration. And I think that's a better resolution.
Okay.
Arbitration is tough for people. Um, Next up here on the signature blocks, please don't skip these blanks. I have them in red. They're so important. If we need to get a hold of this seller and give them a legal notice, then you need to have this information listed. And see this email address? Don't skip it. What happens when the seller leaves town and moves? Usually they take their email address with them, and you would be able to give legal notice by email, which is very, very important for me as the attorney. Then you put your brokerage information, again, the address. Notice there's no email address for the broker. The broker can't be checking email all day, and it's the broker that has to get the notice, not the realtor, not the listing agent. So the seller's got to notify you by mail. And then this little handy little tool down here on line 211, the last line of the agreement, I think this is a great tool for you to protect yourself and say, I got this over to the seller on this date by email, fax, mail, or personal delivery. Put this in your file, and you have a present business record, a contemporaneous business record of you getting the signed agreement to the seller, which you are required to do under Florida law. Okay, before I switch to the next brokerage agreement, does everybody have any questions about
Hi,
the
Sam.
basic agreement?
I have
Hey,
a
Jessica.
question regarding the listing agreement dates. On
Yep.
the first page, we add if we're going to do it for 6 months, September 1st, let's say till next year, September 1st.
Sure. Right here on
When,
line 6. Yep.
yep, but by the time the seller actually reviews and then the wife reviews and then they both actually sign, they execute it on September 15th. But when I sent it to them originally via DocuSign, I drafted it and it said September 1st. So then when I go to add it on MLS, it asks me what date did the listing start? Do I put the date that they signed, September 15th, or do I add the date that the agreement says, September 1st?
I would put the date the agreement says, because you can backdate these to the date you put in here on line 6. So if you're in your
Okay.
example, you put September 1st, they sign on September 15th. The agreement is effective September 15th, but you backdate it to the 1st. So on MLS, I would put the 1st.
Okay, so the effective date of when the agreement start will be September 1st, not the
And
day it's
that's in
signed.
this agreement. I believe and then just to confuse you a little bit, Jessica, because I know you work in NABOR
Both.
land.
Yeah.
The NABOR agreement, I think, is a little different. So
Okay.
this one, you would put the date you wrote on line 6 here.
Okay. All right. Thank you.
Other
Hey,
questions about this
Sam.
agreement? Yep.
Sam, just one quick question, because you just mentioned NABOR. It appears that there is some more detail in terms of this listing agreement versus the NABOR listing agreement.
Sure.
Are there any plans to update the NABOR agreement and add some of those things, or are those just the differences between the two?
What are you looking for in the NABOR agreement that's not there that's in this agreement? Because they're pretty similar in a lot of regards.
I was just looking you mentioned like you can attach the deed instead of, writing
Oh
in the
yeah. In
legal.
terms of features like that, yes. And
There's
then
a
in the
lot of
NABOR
features in
form,
this
yeah.
that
Say it
seem to
again, Mike.
be, there are features in this listing agreement that appear to be more detailed than some of the things in the NABOR agreement. And so I was just wondering if that's going to, over time, going to go away, or no, that's just the difference between the two.
I think that's just the difference between the two. Florida Realtors has a broader audience and a bigger committee. They do different things than the NABOR Legal Resources Committee. I think, Mike, that's just going to be a difference.
And for the brokerage, do you have or from a brokerage standpoint, are there recommendations on which agreement is stronger or better?
No, not. I actually think of it more from the perspective of if you expect to get a NABOR, and it does not go both ways when I say this next sentence. If you expect to get a NABOR sales contract, depending on your market, of course, and you're on Marco, I would get a NABOR listing agreement because the NABOR forms match up. Now, if you like the Florida Realtor listing agreement better because of the features, it will not affect you if you get a NABOR contract. Like, it won't matter. But if
Perfect.
you expect a NABOR contract to come in, a NABOR sales contract, and you've got a NABOR listing, the NABOR listing tracks the language of the NABOR sales contract better, so that you can go back to your seller when they don't like the terms of the NABOR sales contract. You can say, no, 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 no. You agreed to this in your listing agreement if you use the NABOR listing agreement.
Got it. Thank you.
Yep.
Sam,
So
a
that's
quick
one big difference.
question.
Yes, ma'am.
Very unique situation. I just took a listing where the sellers have explicitly said they absolutely 100% do not want a specific realtor to be in their home, to show their home, to do anything with their home.
Do that.
Can they exclude that in additional terms?
Yeah.
Sure. That would be allowed.
Okay. And then if
It's
that
not,
person,
as long as you don't say like no black people, no discrimination. That's 100% illegal.
of
But if you've
course,
got a specific person with a specific issue, I think that would be fine because that's not discrimination. That could be a legal issue, it could be a number of things. All right, we are moving right along. This is again the same document that you just looked at, but it is exclusive right of listing 20 SA, which is single agency. So it's all the same. Everything's the same, all the same. No differences until we get to paragraph 11, which I'm going to zoom out so you can see the whole thing. Oops. Single agency. What does single agency mean? For those of you that don't know, I'll give you some detail, but It basically means you represent this seller and this seller only. You cannot bring the buyer. You cannot talk to other people. You are the agent of this seller. You owe them the duties listed in orange are the transaction broker duties. You'll see they're the same. But see these 4 purple ones? Specific duties. It's a higher level of care and it's exclusive to the seller. You must be loyal to the seller. You must keep everything they tell you in confidence. You must obey their direct legal commands, and you must give them full disclosure. So be very careful. And the broker will give you some more detail about agency, but be very careful about this to make sure that if you do a single agent deal, you represent the seller only. Did someone have a question about that? I heard someone.
Yeah. Who uses this? I never used it in my whole life.
Right, Tina. Well, somebody like if you've got a really high value deal and it's a contentious situation, there's a lot of politics involved. You might need single agency to protect the seller. The seller may want it, but you're right. As a realtor, you would almost never want to use single agency when transaction broker is available because you can't get both sides. You're acting more like a lawyer. You have higher duties, more risk to you. And honestly, if you're going to be a single agent, ask for more money. You say, I'll represent you only. Fine, I want a higher percentage.
10%.
Don't say numbers, but yes.
Thank you, Sam.
And Doug is asking, what's better for the seller, Florida or NABOR listing? Doug, they're very similar. They're very similar. I wouldn't say one is better than the other. I'd say it depends on your market, as I was just talking to Mike about. If you're in a NABOR market, Collier County, Marco Island, City of Naples, you're going to see a lot more NABOR sales contracts than you might use the NABOR listing because they match up a little better.
Okay, thank you.
Yep. Okay. Moving right along. Next up, again, same agreement. Everything's the same, except this time we're talking about ERS 18NR. That's no brokerage relationship. Right here. And in the no brokerage relationship, you don't really represent anybody. You just agree to deal honestly and fairly. Johnson v. Davis, disclose material facts and account for the funds, but you don't represent the seller. When would you use this form? When you have the buyer broker and the buyer is adamant that you don't represent anybody but them, where there is no exclusive buyer broker agreement, like there is for single agency. But you can say to them, I won't represent the seller. I'm just getting you this property and the seller's going to pay the commission. So this is what the no brokerage relationship one is for.
Sam, does anybody uses that?
Yeah, people use the no brokerage relationship, yes.
Okay, thanks.
Now this next form, this last one of these 4 types of forms, again, is also the same. But notice, again, ERS 21TN. This is the transition form. So in this form, going down here to section 11, again, you start off as a single agent. Have your single agency notice. The seller signs for single agency, but then they consent to transition to transaction broker. You come back later when you find the buyer and you want to transition, and you have them sign here on line 201 as the transition. I've never seen this form used. If you were going to transition, you would use this form and have them sign here on line 201. Okay. Up next, very similar, is the vacant land listing agreement. This is just like the other agreements. It's a little bit more commercial in the way this one reads, but it's very similar to the transaction broker agreement we went over. You'll notice, however, the personal property section is very, there isn't a personal property section here. We just have the real property section. And basically, the only personal property is related to what might be on vacant land, storage sheds, pumping things like that. Okay, let's close this. Okay. You'll notice here, no public marketing issues. Public marketing does not apply to commercial and vacant land, so you can do some of the other things that you might do to privately market this property before you put it in the MLS. You will just promptly publish in the MLS when you sign this agreement. So you have more flexibility. But again, all this is the same in terms of displaying it in the public and things like that.
Sam, I have a question.
Yes, Jessica.
When it says in these listing agreements that we must put it on MLS within 24 hours.
Yep,
but
one
there's
business day. One
one
business day.
one business day. So if there's brokerages that are saying that we can leave it as a coming soon and not put it on MLS, I'm kind of confused
Well,
why.
Jessica, that's politics. There's a lot of stuff going on between some of the big brokers and NAR, and I'm not fully up to speed on a lot of that, so I don't want to speak to it.
Okay.
But yes, there's a lot of why do I have to do this? Can I have office exclusive listings? You know, it's been in the newspaper, so it's not a secret. But some of the bigger brokerages will
They're
do
debating
things
it
like
right
that.
now.
They fight back at this.
Oh, okay. But
And
the
I'm
contract
not
says.
well versed in realtor politics. I stay out of that. I stick to the law. So that's probably a broker question.
Okay, thank you.
Now, because vacant land can be more of a commercial, you can use the Commercial Real Estate Sales Lien Commission Lien Act, and you can file a lien if you don't get paid, which is a nice feature. We talk about that more in my commercial class, but basically, you can file a lien against the property to get your commission paid if you get backdoored. Again, this is all the same. All of this is the same for the listing agreement. Then we get into this listing agreement. This is a very different listing agreement. I don't know why Florida Realtors puts this out. It's very interesting to me. It is an exclusive. Sorry, I apologize. Whoops, I missed one. This is the right to lease listing. I apologize. We're going to skip to the interesting one in a minute. This is the right to lease listing. The lease listing is also very similar, but you put your rental terms in here. And I'm not going to go through this in great detail. It's fairly self-explanatory, but you've got your occupancy, when your term expires, how you're going to do your rents in terms of yearly, monthly, weekly, and seasonal. Put your season dates in here, your various fees that can be paid, and then your broker obligations are very similar, except they're more of a checkbox style for you to pick what you can do, which I kind of like that better than just listing them all. Advertising is very similar. It's not there is it's a lease listing, so there's no public marketing. Oh, who's not muted? There we go. Okay. The owner obligations, they'll give you the keys, and then you put the addendum for any disclosures that the tenant may need to know. I see Jeff has posted, yes, check with your broker on any single agency. Absolutely. Your broker probably does not allow you to do single agency, so check with them. Okay, so then you've got the time. This is important for compensation on lease listings. Time and manner of payment. When will you be paid? When the property is leased? What if you're getting paid over time? And if it's due in each rental period, so making sure that you get paid appropriately is very, very important. And how you get paid, check the appropriate box. And then owner will pay the broker's fee within the calendar days or whenever each rental payment is due. I forgot to highlight these. Let me highlight these. can go. Okay. And then compensation if the tenant is going to have a broker, how you pay them, that all falls under the NAR settlement. So be very careful how you fill that out. Notice here you pay gross lease, first month's rent, or a flat fee. And then you're going to have a brokerage relationship and you're going to choose. If you choose single agency, don't forget to give a single agent notice. It has to be in writing, signed by the landlord. Don't forget that. Okay. This is the very strange exclusive brokerage listing agreement that Florida Realtors puts out. The only real difference between this and the other listing agreements that we talked about is this line right here in red. Seller reserves the right to sell the property directly to a buyer without the assistance of a real estate licensee, and if successful, does not owe a broker commission. What does that mean, that dangerous sentence to you? It means that if the seller and the buyer come together without you, you don't get paid. It's a great opportunity for the seller to backdoor you. I would not use this agreement, but if you have a seller that says, I know the buyer, I know my neighbor might want this, I want to be able to exclude them, then you would use this exclusive brokerage listing agreement, and it is EBLA 13. And that's really all I have to say about that agreement, other than the fact it's very much similar. You would have a brokerage relationship again, but it's very similar to the standard Florida Realtor listing agreement. I don't like this agreement because it lets the seller backdoor you, but you have it available if you need it. Up next is the limited service listing agreement. This is a short form agreement for marketing only. It's basically for those brokers that just put the property in the MLS and don't do anything else. You have the exclusive right to sell. You put the price, promptly publish it in the MLS, and then you display it on the internet. And then you get your compensation if it closes. It's very similar. But it does have some of the protection languages in it and the brokerage relationship. This is going to be one where you're going to want to have no brokerage relationship in most cases, or you're going to want to have a transaction broker. If you check single agency on this one, you're asking for trouble because you're probably going to get the buyer calling you directly as well. Okay.
Sam,
Yep.
if your broker prefers to use NABOR for leasing, even though the properties are in lien, you're not in trouble, are you?
Not at all. But the
Okay.
NABOR forms work throughout the state of Florida. They do reference Lee, Collier, and Charlotte counties, but they're perfectly valid contracts in the state of Florida.
Okay. Our broker likes the NABOR for leasing better. So.
Well, that's great because I'm one of the people that writes that one.
Okay. Thank you, Sam.
Yeah. Short sales. If you're going to do a short sale, everybody, I have a short sale class you can tune into to learn about short sales, but basically it's where the net proceeds are going to be less. So you sign your listing agreement and then you add this addendum, and then the seller gets zero from the transaction. You can take backup offers. You need rider G for the short sale contingency in the sales contract, and the bank needs copies of all the seller's documents. You can provide those to the lender. And I'm hurrying here because we're already at an hour, and I know you guys got work to do. You got to go sell houses today. Modification. If you're going to modify your listing agreement, this is a great form, the modification form. You check the appropriate box for which one you're using, and then you can change the terms. Termination date can change, the price can change, the comp can change, the commissions change here. The retained by the retainage amount can change if you terminate, or you can unconditionally or conditionally terminate the contract, the listing agreement. With that, those are all the listing forms, and I'm ready to take some questions.
Can a agent require you as a buyer's representative when you're making a contract? Can they insist that you use a NABOR contract over the FAR or FAR over the NABOR?
Say it, who insist?
The listing agent, they'll usually say in the
Sure.
listing, the
Yeah,
seller has requested all contracts to be on NABOR. The
that's
seller
perfectly
doesn't know
valid.
anything about the NABOR contract.
That's perfectly allowed. If you've got a seller who's not comfortable with the with the FAR forms or the Florida Realtor forms, and they want NABOR forms, they can ask for that. The contract can be whatever form the parties agree to.
Okay, but if the seller's not the one that really knows about our contracts, right? It's more so the agent who's requesting that.
Right, the agent is allowed to do that. I don't recommend it because it limits what you can bring in, but you certainly would be allowed to do that.
Okay. Thank you.
Yes, that can be very frustrating for an agent who wants to use a different form. And the reality is we will make any form work. We can use addendum, we can make the forms work.
Can you mix the forms?
No, please don't mix the forms. If you've got a NABOR sales contract, use NABOR addenda. If you got a FAR, use FAR addenda. If you can mix between listing and sales. So if you've got a FAR listing, a Florida Realtor listing contract, and then somebody comes in on a NABOR sales contract, that's perfectly fine. That's okay.
What about the disclosures?
Well,
For example,
that's where you run into trouble. If you fill out a bunch of FAR disclosures, like for a condo, and then somebody comes in on a NABOR form, that doesn't work. You got to use the NABOR disclosures in addition to the NABOR contract, or the FAR forms in addition to the FAR contract. Don't mix the forms.
oh, because I was with some agents, I was doing FAR or the Compass. You know, Compass has their own listing agreements as well.
Right.
And then, but the disclosures, I was using the NABOR because most of the sales in Naples are NABOR contracts. So I was going to make all the disclosures to match what the sales contract would
You want the
normally.
disclosures to match the sales contract. That's right.
Okay, so I can do the FAR listing agreement, but do the NABOR disclosures.
That would be perfectly fine if you expect a NABOR sales contract to come in. Yes.
Okay, thanks.
Yep.
Thanks, Sam.
All righty, everyone. Any other questions? I don't mean to cut you off, but we're at an hour and I know people got to work.
Thank you.
You can always email me separately. Thank you all very much. I'll talk to you all soon.
Thank you.
Bye-bye.
Bye.